to enter an agreed sentence, Your Honor.
She's going to plead as charged to the simple possession of cocaine. We're going to put her back on supervised probation with a zero tolerance when it comes to drug screens, Your Honor. She's been locked up 60 days. She should be clean, Your Honor. And we are also asking that she get a drug and alcohol assessment and follow the recommendation.
Right. Ms. Burchett, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm by the testimony you give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. State your full name for the record.
Cynthia Jane Burchett.
Ms. Burchett, you're here today charged with simple possession or misdemeanor possession of cocaine. Do you understand what you're charged with, and have you and Mr. Clemens had an opportunity to discuss this matter fully, and do you feel like you understand the charges, the sentence you're facing, as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty to the charge of possession of cocaine. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand that you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, Your Honor.
Do you understand that at trial you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena?
Yes, Your Honor.
Do you understand that at trial you'd be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, Your Honor.
But that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you ever get convicted of a crime.
Yes, Your Honor.
You won't be able to necessarily come back in at the end of your probation and expunge your record as you were under judicial diversion. You understand that?
I understand.
You understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead guilty according to this agreement and waive your right to a trial?
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will? You understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty. You understand the court of the state could ask you questions about this offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you're lying under oath.
Yes, Your Honor.
All right. Then I will ask you the simple question: Are you guilty of possession of cocaine?
Yes, Your Honor.
All right. And how old are you?
I'm 24.
24. All right. I am looking at having to sentence someone who is about 24, 25 later this week, and the minimum sentence she's facing is 15 years to serve at 100%. Now, you're 24 years of age. If you have a decision to make, you can choose to pursue a life filled with drugs, and we'll see you in here periodically, and we'll send you up to prison for a while, then you'll come back out, and then we'll send you back again or we'll find you dead somewhere because cocaine is now being laced with fentanyl, and what happens. I'll tell you a story. I had a case over in Cheatham County where husband and wife were going to celebrate they were a young couple like you, and they were going to celebrate their anniversary. Great time to be in love and to celebrate their anniversary. So the wife communicates with the husband and says, I've got a bottle of wine, why don't you see if you can get us some Coke? So he goes out and he buys some cocaine, brings it back. Unbeknownst to him, that cocaine is laced with fentanyl. They found her dead inside the house, and they found him dead out in the driveway. They celebrated their anniversary by using drugs that killed them both. Because when you put that substance into your body at 24 years of age, you don't know where that came from or what's in it, and it could be rat poison for all you know. So you choose from here on out whether or not you're going to live and try to be a productive citizen, or you're just going to live your life teetering on the edge of prison or death. You understand that?
She admitted guilt in court for cocaine possession, giving up her rights in seconds, but then the judge stopped everything. He warned her that today's drugs can be deadly, often laced with fentanyl, and told a shocking story of a young couple who both died after using drugs on their anniversary. The courtroom went silent as he made it clear, this isn't just a case, it's life or death.
And my daughter very much like me alive, so I think I'm almost 3 years sober off that. So,
If you have a child, then you have a real reason to avoid that, because the other thing that I'll tell you about is that people who have drug problems oftentimes don't take care of their drugs, and they get their children exposed to drugs. Then their child, if the child lives, is going to have problems, and likely you're losing custody of your child and so forth. So it all boils down to you making good decisions from here on out at 24 years of age. I vaguely remember what it was like to be 24, and I'm not saying I made the best decisions, but I can tell you I didn't use cocaine. So I will tell you that you need to go through this case and make sure you follow all of the recommendations, because this is your one chance to get probation. If you violate this, you know what's going to happen. You're going to go to jail. You're not going to get any other consideration. I find you guilty of possession of cocaine in a misdemeanor amount. Sentence you to 11 months and 29 days in the county jail. That will be suspended to probation. You are, as a condition of your probation, ordered to undergo an alcohol and drug assessment and follow the treatment recommendations that they give you. Good luck to you. I hope you've learned your lesson.
Your Honor, I noticed that as part of the agreement, Your Honor had advised her she had the right to a trial, proof beyond a reasonable doubt. I had advised her, because this was a revocation of judicial conversion, that you had already convicted her and that this was an agreement as to sentence. That's not the...
Well, I've revoked your judicial diversion, which is different than you necessarily being found guilty of something. So while it may sound as though I found you guilty already, that's not necessarily the truth. But the evidence is there to find you guilty of this offense. So, all right. And that's the judgment of the court. Thank you. All right, then that concludes our business for today. And I think it is basically going to be whether or not we have a trial on Wednesday, right? Roy, do you have a lawyer?
No, Your Honor. I guess I talked to Mr. Clemens this morning. He said there was a possible conflict of interest that they were going to, it would probably be, I was going to ask if he could be appointed my public defender, but he said that there's a potential conflict of interest from that he was going to ask the court, or I should ask the court for an outer county or out of a different public defender, maybe Clarksville or something.
Sure. Clemens, you want to address that issue?
He is correct, Your Honor, and I'll be happy to explain to the court what conflict I anticipate. But otherwise, he hasn't been arraigned yet. If Your Honor were inclined to appoint him an attorney at this time, I would request someone.
I'm sorry, you would request?
But it'd be someone other than my office.
Okay.
we're presenting his case to the grand jury or intend to on January 6th. Your Honor, it's in 5 member status right.
A rather lengthy form that Mr. Royce has filed in this case.
She stood in court as the judge delivered a harsh reality check. This isn't just about drugs, it's about her life, her child, and everything she could lose. He warned how addiction destroys families and can cost custody of a child in seconds. Then the sentence came down, 11 months and 29 days, suspended to probation with strict drug treatment conditions. But the message was clear, this is her one chance. If she fails, she goes to jail, no second chances.
In which he alleges that Lieutenant John R. McDonald, in his official capacity, committed the offense of violation of TCA 39-16-403, also known as official oppression.
Sure. If I may, for the record, Your Honor, I filed that on November 19th. On November 23rd, two deputies, Deputy Davis, CO Davis, and CO Cashmere, came to my cell and asked me if I filed any kind of legal forms or any kind of legal mail, which I, had thrown in my hat. He pulled out of his back pocket that motion, the affidavit of complaint against Lieutenant John McDonald, and said that he found it while cleaning underneath his desk 10 days post when I handed it to the facility staff to get it to the courts in a speedy manner. And so we went ahead and, under his observation and C.O. Davis's, we went ahead and got another legal envelope, sealed it. I signed the flap. He initialed the flap. I also had to obtain a handwritten copy for myself and sent one home. My mom finally, after multiple calls to the clerk to find out whether they filed or received, and on the 23rd or 24th of November, when Casimir took it, my mom called and they said that they'd received it. But I just wanted to get that on the record that it was terrible.
You can get it on the record. What you're attempting to do is to obtain a criminal charge against an officer, and this court does not issue criminal charges in circuit court. That would have to go through general sessions, and it would be up to the general sessions judge or the magistrate, who normally would consider those charges as to whether or not there is probable cause for the issuance of such a warrant.
Yes, sir.
I am going to today go ahead and appoint someone to represent you who may be able to give you some advice, even though your case has not yet come out of the grand jury. When do we anticipate it going through the grand jury process?
January 6th. James Taylor.
All right. Where's our list?
I apologize if I misfiled. I'm just not used to the judicial system in Tennessee or on familiar procedure.
Well, I'm going to appoint Mr. Kendall White, who was just here a moment ago, to represent you. He'll be notified and he'll be in touch with you, but your case has not yet come out of the grand jury, so he will have time to talk with you about it. As far as the issues that you have regarding the issuance of the warrant, that needs to be taken up with the general sessions judge, and so therefore you're going to have to request that your matter be brought before Judge Andy Brigham of the General Sessions Court. I don't have the power to order the General Sessions Court to issue a warrant or not, but that's what you want. That's the other option you have is to request an opportunity to testify before the grand jury. I want you to have the understanding that you have to have a lawyer represent you for your best interest, because if you proceed with these charges, then you're going to have to testify about what happened.
Yes.
In testifying about what happened, you very well could implicate yourself and give evidence that could be used against you in the criminal prosecution of this charge.
Yes.
So it's in your best interest to talk with a lawyer before you proceed further. I'm not telling you not to. I'm just simply saying getting the advice of an attorney before you push the issue of going before a judge and asking for a warrant against that officer, where you're going to have to then testify under oath, and the evidence that you give under oath, subject to cross-examination, would be something that could be used against you in the prosecution for this case. So for those reasons, I'm of the opinion that we need to get you with a lawyer and then let you decide whether or not you want to go through General Sessions Court.
He tried to put a criminal complaint against the correctional officer on the record, but the judge shut it down immediately. This court doesn't issue charges like that. He explained it must go through General Sessions instead. Then things got serious. The judge appointed him a lawyer and warned him that if he pushes forward, he may have to testify under oath, and anything he says could be used against him in a criminal case. In short, one wrong step, and he could end up hurting his own case.
Okay, that's right. Is there a way I can get some, because you gave me the name White?
We'll give you a piece of paper with
my memory's not the best.
All right.
I'd like to have some kind of a record of what I need to do. Sorry, that's up.
All right. We will give you that name before you leave here, okay?
Okay, thank you, Your Honor.
Now, I'm sure we've gone through the docket a second time. Just have a seat. They'll take you back to the jail and let you have that information. What else do we have that we can take up?
Miss Hayes. Does the court
need me for this? I'll wait, Your Honor.
There's a motion to withdraw by Mr. Stanford. Give us a second. We're supposed to be retrieving her from a smoke break that she took without the consent of the court. So. Right. We're calling Amber Hayes' case on a motion to withdraw by Mr. Stanford. Finally, on these motions to withdraw by Mr. Stanford in these cases, are you here to argue them, or are you asking to reset his motions to withdraw?
I think we'd like to have it reset, Judge. I spoke to his assistant, Ms. Stice, and she was unclear as to what Mr. Stanford would have done, Your Honor.
So why don't we reset? I think we've already reset them for January the 12th. So
I just asked that she take a drug screen, Your Honor. But if he's not here, Mr. Stanford's not here, there's not really much that can do about that today.
So is she taking a drug screen? I thought she had already taken one.
She did. Was positive for alcohol, methamphetamine, and cocaine.
So the state would ask that she be back in custody, but I understand.
Call that a trifecta? Is that what that's called?
She did admit to the cocaine and the alcohol use. She has not admitted to the methamphetamine.
Ms. Finley, you may head back to Clarksville.
Thank you, Your Honor. Good to see you, Judge.
Good to see you. Right. I signed this Barnard furlough order, and we are, whatever, is she out smoking or is she take off?
She is allegedly out smoking.
I find that there is a basis for the revocation of Ms. Hayes's bond, and as a result of that, she will be held pending the next hearing, which is January the 12th.
She's actually out on a medical furlough, which that would need to be revoked.
That's revoked as well.
That issue has passed.
If she's on a medical furlough and she is has a positive for alcohol, methamphetamine, and cocaine, and she doesn't need medical treatment. She needs rehabilitation or jail, one or two. But she'll be in jail pending that January 12th hearing.
Yes, sir. Thanks.
All right. So are we waiting on the...
The courtroom turned chaotic as cases got mixed up, motions were delayed, and one defendant was even found away on an unauthorized smoke break. But the judge quickly brought everything back to reality after confirming failed drug tests for alcohol, meth, and cocaine. The response was instant: medical furlough revoked, custody ordered, and jail time until the next hearing. No excuses, no delays, just consequences.